Hi, Joseph. I would now like to present my response by the insurer, Aviva Canada Incorporated, to an application for arbitration concerning the 2-year time limitation period. Part 1 Overview. Is the claimant statutorily barred from advancing a claim in arbitration for recovery of paid sick days pursuant to Section 56(1) of the Statutory Accident Benefit Schedule and Section 281.1 sub 1 of the Insurance Act? Part 2 Facts. The facts of this case are as follows. The claimant, Mr. Tom Ma, is a married 41-year-old male who currently resides in Scarborough, Ontario, and who, at the time of the accident, was working full-time as a tax collector for the Canada Revenue Agency. He was a seatbelted driver of a 2000 Ford Focus that was struck from behind at approximately noon on Wednesday, June 11, 2009. He was then taken by ambulance to the Scarborough Grace Hospital, where, after negative x-rays were taken, was discharged into the care of his family physician. He did not work from the date of the accident to August 7, 2009. During this period of time, he received a payment of $3,200 as an income replacement benefit. The claimant then returned to work at reduced hours and eventually returned to full-time employment by August 29, 2009. He alleges that between August 29, 2009 and February 28, 2012, he used 214 hours of sick leave for which he feels he should be compensated under the Statutory Accident Benefit Schedule. A first denial of the claimant's demand was provided by Aviva Canada on November 11, 2009. A subsequent denial was then issued on December 17, 2009. On November 11, 2009, the claimant was advised that he had received an overpayment of income replacement benefits in the amount of $3,200 due to the fact that he had received full pay from his employer for the same period funded by Aviva. On February 4, 2010, the claimant and his legal representative advised Aviva that the claimant was content that Aviva deduct the time owed for sick leave without pay, totaling $1,054.78 from the overpayment owing to Aviva. Aviva then stated that it would agree to that proposal, but would still require a repayment of the difference in the amount of $2,356.18. Finally, on March 9, 2010, the claimant submitted a check to Aviva for the overpayment. Part 3. Position on the issues. Aviva takes the position that the claimant is statutorily barred from advancing his claim in arbitration as more than 2 years have elapsed since he received each of Aviva's refusals. The 2-year limitation period would have expired on December 17, 2011. Aviva relies on Section 56(1) of the Statutory Accident Benefit Schedule and Section 281.1 sub 1 of the Insurance Act to support its claims that the limitation period for the claimant has expired. Section 56(1) of the Statutory Accident Benefit Schedule states, a mediation proceeding or evaluation under Section 280 or 280.1 of the Insurance Act or a court proceeding or arbitration under Clause 281 sub 1 A or B of the Act in respect of a benefit under this regulation shall be commenced within 2 years after the insurer's refusal to pay the amount claimed. Section 281.1 sub 1 of the Insurance Act states, a mediation proceeding or evaluation under Section 280 or 280.1 or a court proceeding or arbitration under Section 281 shall be commenced within 2 years after the insurer's refusal to pay the benefit claimed. Therefore, it is clearly stated in both of these sections that the claimant has exceeded the 2-year limitation period in which to bring a claim forward, as he was last notified of the insurer's refusal to pay the amount claimed on December 17, 2009. This means that the claimant must be statutorily barred from advancing any claims that he has an arbitration, as over 2 years has elapsed since the refusals made by Aviva. In addition, there have been a number of cases that Aviva has relied on to support its claims that the limitation period for the claimant has expired. And some of these cases are as follows: Zeppery versus Royal Insurance Company of Canada, Haldenby versus Dominion of Canada General Insurance Company, Mugarappa versus Canada Incorporated, and Robertson versus Royal Insurance Company. In each of these cases, it was determined that the claimants were precluded from proceeding to arbitration, as their applications for arbitration were filed beyond the 2-year limitation period, as set out in both Section 56(1) of the Statutory Accident Benefits Schedule and Section 281.1 Sub 1 of the Insurance Act. So to conclude, it is evident from all of the material that has been presented that the claimant, Mr. Ma, is statutorily barred from advancing a claim in arbitration for the recovery of paid sick days pursuant to both Section 56(1) of the Statutory Accident Benefits Schedule and Section 281.1 Sub 1 of the Insurance Act. Both of these sections clearly outline the 2-year limitation period in which a claimant has to bring forward an application for arbitration. In this particular situation, Mr. Ma has exceeded the 2-year limitation period in which to bring a claim for arbitration, and so has no further legal recourse for the recovery of his paid sick days. In addition, there has been a wealth of case law which has dealt with limitation period issues between claimants and their insurance companies. Therefore, it is highly likely that the claimant in this situation will also be precluded from proceeding to arbitration. This is due to the fact that his application for arbitration was filed beyond the 2-year limitation period, which can be found in Section 56(1) of the Statutory Accident Benefits Schedule and Section 281.1 Sub 1 of the Insurance Act. Thanks very much.